important vote that we have to get through today. And hopefully other folks will join us if they can. Welcome everyone, calling this meeting to order. And I don't think I can start this meeting without recognizing the significance of what happened in our country and our state yesterday. We are in some really troubling, terrifying times. And I think it's at these moments when the work that we're doing, even though it may not seem directly relevant, is more relevant than ever. For us to continue to come together in a civil way and explore how to make our laws and our country better. And I hope that this will reinstill in all of us the importance of continuing to expand our efforts on bringing more and diverse folks into our group. I think participation in these activities is really critically important. And my hope is that by the time that my chairship is over, even though I don't have a lot of control over the membership of this group and love every person who's here, that maybe our group looks a little different. I'm hoping that we can continue to convince others of why the work that we do is important. I hope that you're all safe and well, and that your families are as well. And I thank you for the time that you're continuing to dedicate to these efforts. I guess we'll start then with the roll call.
So the folks, we could
have you basically already done it?
Yeah, actually, I've just been doing it in a remote meeting in the background, so I don't think we need to do a formal. We could do introductions if you'd like, but I know there was one potential new member who was going to come today, who is the new dean at Willamette, but I don't believe he's in attendance right now. So everyone else should know each other.
Okay.
And I have roll taken. Great.
That saves us some time then. I saw Susan Graby joined us too. Welcome, Susan. Welcome, Shanna. So let's then go to our first order of business, which is the one that requires our vote and our quorum today, which is the review and vote to approve the Chapter 111 bill. And I think, Lane, you were going to take the lead on that. Is that right?
Yeah, I think it'll be a combination of Lane and Susan, and then potentially with a little bit of input from our partners from the Bar Association.
Wonderful. Then I'll turn it over to you folks.
Okay, I'll lead off and then invite Susan to share her wisdom on this as well. I guess what I would say about this bill is, and I'm happy to go through any sections you want to talk about. I didn't plan on walking through the entire bill, but just to explain basically, this bill is primarily, it's procedural more than anything else. There's not a lot in the way of deep policy choices reflected in this bill. And to the extent that it's procedural, most of it is intended to codify what is generally accepted as practice, but not currently explicitly codified in the probate statutes. So the focus of it is really fairly narrow, notwithstanding all of the bold text. I think probably maybe the most substantive element of the bill is right up front in section 2, where we deal with this issue that probate practitioners and probate courts have just kind of had to make their way through, and that is, to what extent does the ORCP apply to various proceedings were within a probate case. And the reason this becomes important is that the standard now, the general statement now is that the ORCP just does not apply generally to probate. But in fact, we know that in the context of a probate proceeding, you do have contests that occur that are very much like litigation. In that they may require discovery, they may require the application of various rules of civil procedure that do apply to litigation, and they don't clearly apply now. And so the section 2 is very thoughtfully developed in consultation with probate practitioners who deal with these kinds of contested proceedings. And what we've done is we have pulled out a category of a class of things that occur within probate that really do amount to contested case types of events. And we are very explicit then in terms of applying certain of the rules of civil procedure to those. And it's really intended to clarify when you are in one of these contested issues, when the rules of civil procedure apply and what rules of civil procedure apply. And so, you know, that I think is probably I'm going to say I think it's probably the most substantive section of the bill. The rest of it, you know, expands on what constitutes notice, how notice is given, who's entitled to notice, how proof of notice is made. You know, I don't think I would go into any detail in my at least initial presentation on this. I'm happy to answer any questions on any of these sections that you have. But again, to underscore that this is primarily intended to assist in the procedures in a probate case. And I think we have not, we've tried not to make any strong substantive or policy changes in this bill. I guess I'll stop my introductory comments there. We have Professor Gary. Susan's the reporter on this. I'd be happy to have her comments as well to augment or amend mine. And Lori Ann Sills, who just did a bang-up job as our Legislative Council drafter, is on this call as well. And I know Lori Ann can provide a lot of explanation. The last thing I'll say before I turn it over to Susan is about the next to the last section, section 24. That came to us by way of request from the bar. This was not a section that our work group developed, but we got the request from the bar to include this. This was from the Council of Court Procedures, as I recall. But it relates to probate proceedings, and so was within the subject line of the bill, the relating clause, and so we've accommodated their request to include that. It did get review and discussion by the work group, but is not at least an initial product of the probate modernization work group of the Law Commission. Susan, or do you want to add your comments, and then Lori Ann, if you have any, and then be happy to answer questions from any of the commissioners.
I really don't have a lot more, well, don't really have anything more to add. I was going to say the same thing that Lane has already said, that the real focus of this is on when the rules of procedure apply and don't, and when a probate proceeding goes from being something where the rules wouldn't appropriately apply, becomes a contest, and the rules do apply. And I think that the clarification is going to be very helpful. That's the sense I got from the work group. The one other thing I'll say is that, as Lane has said, Lori Ann Sills was with us the entire way. And I think it was really valuable and helpful to the work group to have her participate in every meeting. It really was incredible because she could raise questions that people had thought about but needed clarification in the way the drafting happened. So I think part of the reason it's a really good product is that she was involved not only in the drafting but in really thinking about how the drafting gave effect to the intention of the work group. That's all.
Lori Ann, do you want to add anything?
Hi, I actually don't really have anything to add, except this was an interesting project to work on, and I'll be curious to see how y'all vote on it. So I'm happy to answer any questions if folks have them, but I don't have anything prepared to talk about. So
yeah, so PK, I think we'll just open it up to questions. Like I say, there's not a lot of deep lawmaking going on here. It's mostly of interest to practitioners and courts, just in how these cases move through. But you're all, smart practitioners, and some of you, I'm sure, have extensive experience in probate, so may have particular questions about sections or things that we've done here, and I'd be happy to try and answer those.
PK, I see a question from Judge Bouchon.
Go ahead, Judge.
Hi, I do have a question. I don't have any expertise in probate, but my question, I noticed in the list of the ORCPs, not included are the ORCPs that deal with TROs, preliminary injunctions, provisional process, that sort of thing. And my question is just why? Does it not come up in probate, or is it or how would those be handled in a probate proceeding?
That's a good question. And honestly, I don't know the specific answer to that. This list of the ORCPs was exhaustively reviewed by the practitioner, by basically our probate litigation practitioners, the ones who really do litigate. And I think we had Judge Cobb involved in that as well. I'm going to say it never came up in the conversation, probably because it doesn't come up in probate. I've never encountered it. So apart from that, Judge, it's a good question, but I don't know a specific answer. And Lorianne, you may have met with that group as well. Do you recall it coming up in the conversation? I know they went section by section through rule by rule through the ORCP, obviously, in pulling these out, but those rules did not come in.
Yeah, I don't recall having a discussion with the litigation attorneys about how that decision was made.
Do you folks think that the inclusion of some things and the exclusion of others is going to limit the authority of judges in applying things that are like the remaining rules or that are excluded? Susan, I see your hand up. Susan Gravy.
Thank you. Hi, PK. Hi, members of the Law Commission. I appreciate all the work you do and all the people who contributed their time. It's really fantastic. So thank you, first off. But in partial answer to that question, and some people may not be tracking on it perhaps, but the Council on Court Procedures is a group that looks at all of the rules of civil procedure. And it works on a parallel track. It's a little bit confusing and it's an unusual beast, if you will, but ORCP changes can be made by legislatively, but ORCP changes are also made as a whole by the Council on Court Procedures on a regular basis. And they issue a report to the legislature at the beginning, just prior to session starting, of their proposed changes. So there's two avenues for ORCP changes. And I suspect, Judge Bouchon, that some of the other changes that you might be interested in might be addressed by the Council on Court Procedures at different times, perhaps not this go round, but at other times in the process. And that this probate group was focusing on the probate issues that they saw that came up more frequently. That's my off-the-cuff response, if that's helpful.
I also saw Mark Comstock, and then back to Judge Bouchon.
Thanks. Maybe it's just my experience of being a bull in a china shop, but I have used provisional process and TROs in an estate to attempt to stop a foreclosure sale. And the judge didn't raise any question and nobody else did. So we used it anyway. But the second point, I'm a bit troubled by the lack of application of the Oregon Evidence Code. And I'm just trying to figure out what the reason is for the evidence code not applying. I would think that a challenge to the foundation of a trust or a will or whatever it might be would be grounded in the evidence code, and I'm just trying to figure out what the reason is for that. Thanks.
Sure. Yeah. Well, in fact, if you look on page 2, line C, the evidence code does apply in a contested issue, and so I'm looking here. Are you saying a will contest? For instance, a will contest is specifically covered, included in contested proceeding on lines 23 and 24 of page 2. So that is the context in which the Oregon Evidence Code would apply. I think what we're saying here is if you're filing an annual accounting, there's no evidence involved in filing the accounting itself. We're not worried about the application of the evidence code. If somebody contests or objects to an accounting, then the evidence code does apply. And so I think that we've tried to be a little bit surgical in defining when it applies, but the evidence code does apply to those kinds of proceedings. And let me suggest maybe an answer to Judge Bouchon's question. And Steve, or Mark, I'm not sure how you would have done this, but this definition of a contested proceeding relates to proceedings all that come within the case, within the probate case. If there is a case brought outside, maybe an action for a preliminary injunction against the personal representative, or the personal representative files a proceeding for an injunction against another party, that other proceeding is a separate proceeding, and to that the ORCP would apply, as well as the evidence code. This only deals with proceedings that are actually within the ambit of the probate case itself, and so it doesn't relate to cases that are brought either for or against the estate as a separate proceeding, if that makes sense.
Okay, I do have one question. As I read it, the summary determination of a claim is one that is not subject to the evidence code. I mean, I see the same authentication of documents for a claim that would be before the court, and I'm trying to see if the court is moored to the evidence code or not in that type of proceeding.
Yeah, and I think the policy call on that was that summary review is already just kind of a sui generis thing. That courts manage those in different ways and informally. And so I think the sense there was not to make a summary review like a trial. If somebody wants to get into that level of rules of evidence and rules of procedure, a separate proceeding can be filed to, outside of the probate case itself. That's an option to a summary review. But if it's a summary review just within the probate case itself, then the sense was that we would maintain the current policy, which is to treat these as just weird, informal things and not turn them into the trials.
Judge Bouchon?
So I think Lane partly answered my question. Susan Graby's response that the process for amending the rules of civil procedure, that wasn't what I was getting at. I'm not talking about amending the ORCPs in any way. I'm talking about this provision that lists the ORCPs. I'm talking about subsection 3B of section 2 of the bill that lists the ORCPs that would apply in a probate proceeding. And it does not list any of the TRO, preliminary injunction, provisional process type provisions. What I understand from Lane is that if you wanted to pursue those sorts of remedies to prevent someone from, disposing of assets that are within the probate estate, you would have to file a separate action and not bring that TRO proceeding or preliminary injunction proceeding, or as Mark said, to prevent a foreclosure for that matter. You'd have to file a separate action to do that, not bring it within the probate proceeding itself, which I'm not a probate lawyer. And if the probate lawyers are all fine with doing it that way, that's okay with me. It just struck me as maybe a little cumbersome.
Yeah, Judge, that's a good question. I've never done it, but among the probate practitioners, the litigators, that were on the work group, that certainly was their sense.
I'm not sure that my question has been answered though, which is that, does the inclusion of some of these rules and standards, in this bill purport to limit the judge's authority to do other things? It would seem to me in general that, a judge has power through equity to do what is necessary, but Judge Bouchard is probably going to call me on that. Go ahead.
As I read it, the prior section just says, except as stated in this bill, the rules of civil procedure don't apply. So that's the general rule.
Right.
And then the bill lists all the ones that do apply. So I think if it's not listed, it doesn't apply. I think I'm guessing that's the intent of the bill.
And I think that's true. I want to get back, PK's question was phrased just a little bit differently. This doesn't limit the court's power in any way. This only applies to the rules that govern the proceeding. If you look at section 6 in the bill, it's on page 7. We retain the broad statement of authority of a court. Probate court has the general legal and equitable powers of a circuit court. And so the court still has the power to fashion remedies and to do things. So this list of these rules of civil procedure in section 2 doesn't in any way limit the court's authority. It just tells lawyers basically and the court when one of these things happens, then in the context of that, these rules are going to apply to the process. But it doesn't in any way limit the power of the court in how it deals with these things, or the parties for that matter.
Thank you.
Well, looking at section 3 of the bill, it seems to put some fencing around when a court can or cannot have, or when a court can or is required to have a hearing. And I'm just curious, is it the contemplation that a court would have to enter an order to show cause for the court's own motion to deal with something?
I'm not sure. You're looking at section 2?
Section 3.
I'm sorry. Yeah, subsection 2 though, because the first one is just permissive. The court can. Section 2, hearing must be held on a petition or a motion if an objection to the petition or motion is filed. So yeah, again, what's the question there about a court, something on the court's own motion?
Well, I'm just trying to figure out what does this in any way limit a court's ability to cause something to have a hearing?
No.
I mean, if let's just say an estate has been pending for 5 years, does the court have to jump through a bunch of hoops to send out an order saying, come on down and explain why you haven't closed the estate?
Okay, so that is in section 1. A court may require that a hearing be held on any petition or motion in a probate proceeding. I don't see that as limiting.
Okay, all right.
Yeah, I don't see that as limiting. And so, Susan, in your report, you might want to make a note of that. That here, I think we're really talking about this is permissive. It's not intended to be limiting in other circumstances where a court could require a party to appear in front of it.
Judge?
So maybe I'm answering my own question, but looking at section 6 of the bill, starting on the bottom of page 7 and going into page 8, that lists all the things that a court may do, probate court may do. it can exercise jurisdiction over any transaction entered into by a fiduciary, determine ownership of title for real or personal property. So perhaps some of those things that I was concerned about, disposal of property,
Right.
foreclosure against property, certainly within the court's authority and jurisdiction, it seems like the court then would have broad discretion to determine what procedural steps it would follow in addressing those issues, since the, ORCP 79 doesn't apply and the TRO provisional process rules don't apply, but it looks like it's within the court's authority to address those. Just procedurally, maybe that was the idea, is we'll just let probate courts figure out the best procedure without tying them to the ORCPs, which I'm fine with. I'm not objecting to that. I just wanted to understand it.
No, that's a good point, and I think it's a good observation as well. I think it's important to know that this was not intended in any way to limit what the courts currently are able to do in managing these things. I think in setting out that particular class of things that constitute a contested proceeding, it's really intended to signal the parties as much as anything when the rules are clearly and certainly going to apply. But I don't think we intended, and I don't think this bill does, in other ways limit the authority of the court to manage these things.
I think might be helpful to include those things in our explanation of the bill, so that folks know that.
Good question.
Any other questions? Okay. Well, hearing none, shall we vote on it?
Yeah, PK, one thing really quick, don't want to interrupt, but I realized that one person is actually new. Actually, two people are new, and I hadn't recognized.
Oh.
And I did want to make sure before we vote that people know who's representing which organization. Kimberly McCullough is actually representing the Attorney General's office, and I failed to mention that earlier. So thank you for being here. And that's new. And then also Brian Galini, make sure I get your name right. We haven't met, but is the new Dean at Willamette. That's correct?
Yeah, good morning, everyone, and thank you, Sandy. It's good to be with all of you.
Thank you. So I want to make sure that everyone knew, as we call the voting roll, they're both a part of that. So I want to make sure that everyone was aware.
That's great. Welcome, Brian, and welcome, Kimberly. I thought there were some new faces, although Kimberly, you are not a new face to me, even though I don't see you.
Yeah.
Hi.
Nice to hear you.
Welcome. Let's take a vote, and then afterwards, for the benefit of our new folks, let's just go around and introduce ourselves real quick. Take a few minutes. But let's go ahead and proceed with the vote then. All those in favor of approving this bill on behalf of the commission, say aye.
Aye.
Aye. Any opposed? And any abstentions? Oh, good. No one's being tricky today.
Thank
Hey,
you very much.
great. This is approved. Thank you so much to the committee for all of their hard work. Let's do a quick introduction then. Sandy, I think everybody knows you, so I'm just going to skip you. Hi, Sandy.
Hi.
And I'll just call on people in the order I see them on my screen. I'm PK Runkles Pearson. I am chair of the commission and have been for a short time, trying to fill the very large shoes of our former chair, Mr. Lane Shetterly. I'm currently in private practice as a partner at Miller Nash Graham and Dunn. Some of you may and some of you may not know I'm going to be leaving private practice at the end of the month to join the Secretary of State as her new general counsel. And I hope to continue. Oh, I see Susan Fraby. Thank you, Susan. And I hope to continue as chair of the commission. At that point, I don't see any concerns with that at this point. So you'll just be seeing me again from my home office, but in a different role. Debbie Thurman, would you like to introduce yourself?
Debbie, you're muted.
Good morning. My name is Debbie Thurman, and I'm the administrative coordinator for the Oregon Law Commission. I worked for the law school for 35 years, and so this is a really nice transition for me. So.
And I just want to say on behalf of Debbie is I've recently taken on some additional responsibilities at the law school along with the law commission, and Debbie has been a huge help in ensuring that we keep our continuity of service together. So thank you.
Thank you.
Debbie is indispensable. Mr. Comstock.
Hi, Mark Comstock. been on the commission for a couple of terms. I'm a private practitioner in Salem. I was with the Garrett Heeman Robertson firm for about 38 years, and now I'm doing stuff at a slower pace, but still have lots of people, shall we say, giving me a call. So that's who I am.
Mr. Shutterly.
Thank you. Lane Shetterly. I'm a private practitioner in Dallas, former chair of the Law Commission. Thank you, PK. And that's great to hear about your new position. I had not heard that. So congratulations to you. It avoids the question I was going to ask you about elevator rides in the post-pandemic world, getting up to the 36th floor or something like that in your building. So good for you.
Those rides are terrifying.
I'm also a member of the Uniform Law Commission from Oregon, and so have an interest in the Limited Liability Companies Act. And so I was just going to hang on and listen to your conversation about that. So otherwise, I'll just mute myself and enjoy your company.
Wonderful. Always good to have you back, Lane. Susan Gary. Susan Gary.
Hi, Susan Gary. I'm on the faculty at the University of Oregon School of Law. I've been on the commission for a while now as the representative from the law school. And as Lane said earlier, I've been the reporter for the Probate Modernization Project, which has continued on for a very long time. We keep thinking we're reaching the end, but we're not.
I believe it's on year 8, by the way.
Yeah. Glad to have Lane here to help explain this last version. Thanks.
Your Honor, Judge Bouchon.
Morning, everybody. I'm Steve Bouchon. I'm the currently the presiding judge of Multnomah County Circuit Court. Been in that position for 3 years. I've been a judge since 2008. And before that, I've been on the Law Commission for a while now, and I can't remember exactly when I started. Before I became a judge, I worked at the Oregon Attorney General's office for 14 years. And before that, I was in private practice for about 9 years.
John Perry.
Okay, hello everyone. So I'm John Perry and I'm the Lewis and Clark Law School faculty member on this. I don't remember when I started with this commission, but I do know it was when Bernie Vail stepped down from it. So that's kind of the timing. And it's actually Bernie who made me excited to be part of it because he always spoke really highly of it. And so I'm sorry. Well, I don't know if I should say it. I will say I'm sorry I missed the whole conflict of laws project since I teach conflicts. But who knows? The Supreme Court's finally started to pay attention to it, and maybe we shall see. But it's great to be a member of this commission. I'm really happy to see Kimberly McCulloch on the commission since she was a student and a research assistant of mine. And it makes me feel a little bit old, but I'm really, she's been a fantastic lawyer, and it's good to have her part of this group.
Aw, thank you.
Krista.
Hi, I'm Krista Obold Eshelman, and I've been on the commission for a couple of years now as a bar appointee. I am a public defender in juvenile law, only do appellate work. At this point, I work for Youth Rights and Justice in Portland.
Great. Susan Graby, I know you're not a member of the commission, but you're with us often. Would you introduce?
Hi, thank you, PK. Susan Graby, Public Affairs Director at the Oregon State Bar. Thrilled to be here and just want to reinforce what great work this group does and really appreciate the coordination and the work we all do together. So thank you.
That's great. Thanks. And Amy Zupko, I think you're on still as well.
I am. Hi, I'm Amy Zupko. I work with Susan Graby at the Oregon State Bar, and I am here to help. So let me know if I can help with anything.
Wonderful. Have I gotten to all the members of the commission other than our new folks? Great. Brian, would you take a few minutes and introduce yourself as well?
Yeah, sure. Thank you, PK. And I echo Lane's congrats on your new position. That's exciting. My name is Brian Galini. I don't know that I can still use new, but I feel like I'll use it for as long as I can. New dean at the College of Law here at Willamette in roughly month 9, although it feels like year 9, given this first year and the many things we've encountered learning to run a law school all over again. I write and teach in the criminal law and criminal procedure space, and made the decision to teach in my first year. I'll start with the first year students next Tuesday in criminal law, and taught a class in police discretion, really focused around post George Floyd and the discretionary decision making and really blue collar policing last semester. Really rewarding first semester with our students. I joined you from the University of Arkansas, where my wife and 2 boys who are 7 years old and remote first grade are excited to be here. We were there for a little over 10 years and served in a variety of administrative roles across 3 different associate dean terms. And against my best efforts, most people know me for serving as the head coach of 2 men's hockey teams, both at the University of Arkansas and the University of Pennsylvania. So really wonderful to be with you, and thank you for the opportunity, PK.
That's awesome. It's great to have you here with us. Kimberly, would you take a few minutes for those of us who don't know you?
Yeah, hi, I'm Kimberly McCullough. Sorry, joining you by phone today, so I can't see your faces, but I am working as the legislative director for the Office of the Attorney General, and I have been in that role now since the end of September. I did about a year at the Office of Public Defense Services, and prior to that, I was at the ACLU of Oregon, and then at Davis Wright Tremaine doing litigation prior to that. And yeah, I just love being in the policy space, and I'm excited to join this group and be able to work with y'all. So happy to be here.
That's terrific. And of course, there are a few members of our commission who aren't with us today. Hopefully, maybe we can get them to introduce themselves next time if we can remember who was here and who wasn't here.
I have record.
Oh, great. Thanks, Sandy. So I think our next thing is to move to the status of other ongoing projects. And Sandy, are you going to talk about probate modernization, or are Lane and Susan going to take that on?
I mean, I can prompt what the 2 projects I was going to touch on, and then I can turn it over to Lane and or Susan if anyone's interested in detail. But the 2 things that this group had worked on is one of them is a remote attestation bill, which the commission approved over the summer to potentially be a temporary bill, which we tried to get considered during the special sessions. That bill was not considered, but the group does feel that it would be a positive change to law for outside of the pandemic, based off what's happened, and that's a bill that we're hoping to have considered during the 2021 session. And then the probate modernization group is scheduled. We haven't scheduled another meeting yet, but is looking to continue its work on e-wills. I know that's could be a challenge moving forward, but those are the 2 bills that the probate group is currently working on.
Anything to add, Susan, Lane?
No, just the remote attestation clause. You did approve that to be introduced in one of the special sessions this year. I think the sense of the committee was that it still is meritorious, both because the pandemic is continuing and also just because for future use it has some utility. So I think the sense of the committee, the work group, was that we would hope to see the bill reintroduced for adoption this year, along with the continuation of the remote notarization bill as well.
I know from the practitioners in my office, remote notarization has been extremely helpful. So it's, well, we do good work all the time. It is rare that we have the opportunity to do good work that is so timely and so immediately practical. So that's amazing. Should we talk about notarial acts?
Yeah, Mark is here as the, and I didn't really prompt anyone ahead of time. Mark's here as the chair, but we're very proud of the work we did over the summer. And we do, just to let you know before I give it to Mark, we do have a bill that has been updated to remove the sunset clause to hopefully be passed as a permanent law in 2021.
Great.
And I have nothing to add to what Sandy said. We're just hoping to get in the game and get permanent remote notarization as an option.
Do we have anyone who we know at this point is willing to run with that bill?
Yeah, in fact, Chana is here on the meeting. I know has helped to ensure that that bill will be introduced in judiciary. And at least it's on tab. Again, I don't really have any specific updates about the state of the session, but assuming there is a session, which I know there will be, we know we'll hopefully have an opportunity to present on that bill. And I actually spoke to folks in Secretary of State's office yesterday as a part of another meeting, and they are they have not heard any fundamental complaints about it. Everyone's really happy about it in practice, and we really do hope we can have that accepted. It's something I'm personally really proud of the commission that we were able to get past during the pandemic, and I really hope that it can become a part of Oregon law forever.
That's great. Thank you, Chana, for your help on that. Direct criminal appeals.
Yep, and really quick, and I talked to Krista there. I'll let the group know, and I'll let Krista speak on the project, but there are two, this group is being co-chaired by both Justice Duncan and Krista. And I realized, and Krista reminded me, that the group actually needs to officially change its name in its operation. It was passed as the Direct Criminal Appeals Group, but it's actually dealing, it's kind of moved its work into municipal and justice court work, and now includes both criminal and civil cases. So we do have a project ongoing, but we do need to change the name. So Krista, I'll let you provide a short update, but I wanted to bring that to the group first.
Thanks, Sandy. Yeah, the group has been meeting for some months now, and I think we've been trying to figure out really how to approach this issue, which is the appeals in the justice and municipal courts the statutes are rather scattered around various parts of the code, and in some ways are very similar, and in some ways are different from each other and other and direct criminal appeals. And so we've been working on a number of documents to try and organize our thought process, and Jim Nass has been really instrumental in helping us to do that. So that's been great. At this point, where we're at is Legislative Council is going to be drafting sort of a working document for people to comment on in order to give us something to work off of as we try to figure out the similarities and differences that need to be in place or don't in these various categories of appeals from different courts. So I think they are probably working on it now as the legislative session has kind of kicked off or is about to, and hopefully we'll be able to resume our work group work soon after that document is done.
That's great. And it's good to hear that Commissioner Nass is being of such help to you. I'd hoped he'd be really involved. Should we talk about e-hearsay?
Yeah, e-hearsay, just a short update. Unless someone joined over the phone I saw recently. Is that Keith by any chance? If it's not, I'm happy to update. I didn't know if he was able to join, but Keith Debenovich, this is a project that he had been championing for quite a long time. We actually have a final, and I wanted to wait until we were able to get a meeting where I really want to have an in-person meeting for this one, actually, to allow the fellows who wrote the report to be able to present the report. But we do feel now that this is a project that is at least ready to bring a group together to study it at the very least. It's a complex project that involves looking at the evidence code and potentially proposing changes to the evidence code or not, related to various forms of electronic evidence to try to make them more consistent in the way that it's looked at by judges. The initial class of Oregon Law Commission fellows at the University of Oregon worked diligently on this project and did a really wonderful job. And I know Keith is still behind this project, and we're working on trying to figure out who we would need to have as a part of the group. This is one that's definitely gotten slowed. It's been slowed by the pandemic. I think we had some really good momentum, and now this is a tough one to get going during it. But I still feel like it's a viable project, at least for study and to hopefully present something. And that's my update on that one.
Sounds great. I think realistically, it may be a little while before we'll have an in-person meeting. So
Agreed.
need to just see their faces remotely. But yeah, it sounds wonderful. I'd love to hear more about it. Oh, right, LLC modernization. They're
Yeah,
working hard.
I'm the one who's here because this one is being chaired by John DiLorenzo and really been led in person by Valerie Sasaki, who's done a really just phenomenal job with this group. This group's now been meeting for almost 2 years, which is incredibly hard to believe, but has done a incredible amount of work already and has a lot more to go. This is a massive project to rewrite the Oregon statutes regarding limited liability corporations. We have we've met monthly during that entire time. We've never actually had a month off as far as I can remember. We are now through chapter 8. If anyone is familiar with the document of the Uniform Limited Liabilities Act, this is a very, very large bill, and I'm just really proud of this group. The amount of work that's gone in. I know Susan has been at, Gravy has been at several of those meetings. It's a diligent group. The discussions that are having and the type of policy that's being considered is really interesting to kind of weigh the policies that the Uniform Commission is trying to bring in and weigh that against values that the legislature has brought in terms of how business should be conducted with limited liability corporations in Oregon. So I think that there's a lot of things that the Uniform Act brings, which will help us become more in line with neighboring states. But there's also sections to protect from things like shell corporations and fraud, and that the legislature has felt very strongly about. And we're going very carefully through each section to ensure that we are going to commemorate those in our version of the bill. It's certainly not a wholesale passage of a uniform law bill. We're taking the large scale of it and kind of adapting it to Oregon. This was always a project which was going to take some time. Right now we're targeting 2023. And then I sincerely believe that this group could then transition itself at that point, once the LLC project's done, to look at other business entities. And I think that it's planning on doing so later. So I think this is a really wonderful project. It's a huge lift. We have great partnership and support from the Bar Association on this one. And it's one I'm just pretty proud of, but it's, you're not going to see a work product for a while, but it's going well.
Yeah, this is a really thoughtful and dedicated group. I wonder if at some point, if they switch to a new, a new entity, it might be worth also considering whether there are other folks who might want to add or not be added. I know there's some folks there who are specific to, I think, real estate, interests like that tend to have more LLCs, but yeah, I think
I think we're still 2 years away from that discussion, to be honest. I think this group has quite a bit of work left, but it's a great group.
Maybe we should take a pool to see which one's going to end first, the LLC or the probate crew. All right, any questions about any of our ongoing projects?
PK, I actually realized, and we both looked at it, and we actually didn't include the Partition of Heirs project, which we're both working on. And I want to make sure you were able to talk about that.
Right, the Partition of Heirs project, as many of you know, is about sort of reconsidering those moments when folks inherit properties through a tenancy in common. And there have been some problems when real estate entities have come in and tried to sort of separate out the tenancy in common and enforce a sale, which may deprive folks of the value of, really long held family properties. So we felt like we were about to launch this right before the pandemic, and then things kind of got away from us. But we are in the process of putting together a really good working group on that. At some point, Judge Bouchon, in light of some of your current caseload, which I know you can't talk about, but I'd love to hear about, your thoughts on turnover of property in some of our neighborhoods in Portland, and see whether there are any folks you might think of as helpful to include on our group. But if anyone has thoughts on who would be helpful in that area, that's suggestions are always appreciated. So, right. So any questions about any of our ongoing projects?
And just a quick, if there's no questions, just a quick update on what to expect from the commission is in the 21 session, which again, we don't really a lot of details about that. But what we're planning and what we've worked with the folks at the legislature to have the commission present, we really tried to keep it small because we did know there was not a lot of assurance of what the session would look like and the focus and the way bills are presented. The Chapter 111 bill, which was just approved today, was always when we were targeting. The Notarial Acts bill without the sunset clause to make it permanent. The attestation bill because that had already been approved. And then there was actually a very, very small cleanup of a previously approved probate modernization bill, which was supposed to be heard in 2020 before that session had its challenges. So that's what we're looking at in 21. And the timeline for the other groups is unclear, other than we're trying to really work for the LC group bill for the 23 session. And I hope we're able to get the appeals group bill by that time as well. I think there's a real good chance at it. Once we see the work that Jim and the chairs and the legislative council are doing with the kind of basis bill, I think we'll get to that point. The other projects I don't have a timeline on. I did want to mention, if anyone does hear, I think that from my perspective, we could have the capacity to potentially start a new project at this point. I'm not certain. It depends on what type of project it is. But if anyone does hear or think of any projects, whether they come from the uniform law side or if they come from constituents or areas of interest from faculty members, things like that, feel free to let me know, and I'm happy to work through that. Judge Bouchon?
I almost hesitate to mention this, but Hardy Myers worked for many years on review of governmental, judicial review of governmental actions without success. There's been some recent case law at least from the Court of Appeals, that has pointed out some of the problems in this area, particularly judicial review of orders in other than contested cases. It may be worth taking another shot at this because it's a problem area. And I think it's very confusing to practitioners who wish to bring a challenge to some governmental action. And there are so many different ways and so many different ways to get tripped up that having something clear and understandable would be nice. Now, Hardy worked for years to try to get this, accomplish this, and there were so many different interests that put up roadblocks that if Hardy couldn't get it done, I don't know if anyone could, but I just throw that out there as something that may be worth taking another look at.
Yeah, I've encountered that issue a couple of times. You're talking about like writs of review and that sort of thing.
Writs of review, definitely, and that's part of it. There's the provisions of the Administrative Procedures Act that apply to state agencies.
Mm-hmm.
The idea was that Hardy's work group was working on was try to have an easily understandable way for ordinary people who want to challenge a governmental action to know what process they would follow to do that and what the standards were.
Mm-hmm.
It seemed doable, but was not. But yeah, writs of review, there are, you know, sometimes we have writs of mandamus, we have in the circuit court I'm talking about,
Mm-hmm.
As well as petitions for review of governmental actions, both in the circuit court and in the Court of Appeals under the APA.
Right. I think sometimes in that area, even figuring out what is an agency can be one of the hardest questions, since we have so many different governmental entities. That is a really big bite.
Just a little bit of history on that, because it was very painful. I lived through it. It was not only Hardy, it was also Hans Linde, who both pushed that rock up the hill. And it was focused on local review of government action, local government actions. And yeah, I mean, I thought it was a worthy subject. I do remember it getting heavy crossfire from the League of Oregon Cities, the Association of Oregon Counties, Special Districts, all of those organizations that represent groups. Sandy, there may be some history on this that you could look at in the files of the commission. It was extensively worked, and I think they took at least a couple of runs at it. We were never successful getting it through even one of the policy committees in the legislature. It did have a cast of thousands involved in it. I still thought, as a matter of policy, it was a worthy project. Boy, the politics of it got to be really difficult. Then again, that was 20 years ago, so things have changed. Players are different, and it may be appropriate to look at it. But I'd start there probably, seeing if you can find history of it.
I think that's a great idea, Lane. And the case law that I was referring to recently was more focused on review of state agency actions, which creates its own set of problems. There is a recent Court of Appeals opinion. I don't have the citation, but Sandy, you can easily find it by the author of the opinion is one Judge Lageson. So you can find that dealing with the APA.
I also litigated a case involving whether or not Portland Community College is an agency, which was very interesting. It came up recently.
I actually had an attorney reach out to me about this project looking for documents. So I know we have them all because it may have been one of the attorneys who was litigating that case. It probably was, who was interested in the commission's work on it. So we have all the records, certainly.
Well, I think what might be helpful, Sandy, as you're looking through those things, is to think about how we would break down the questions, into, smaller bites so that we could, maybe make some progress, starting with something smaller and moving up to something bigger. I am reluctant personally to take on a project of that magnitude until we get new members. I've been for a little while concerned about the fact that we don't have a full complement of members, which is something we're going to be talking about later on. But that is really going to require someone who's very dedicated to shepherding a project over a lengthy period of time. And I feel like those of us who are currently involved are already, handling one or more projects. So that's my feeling, at least. But it's certainly worth working up what the project would look like. Well, speaking of capacity, maybe it's time to talk about the budget, which is a little less dire than it was last time, fortunately. Yeah. Sandy, why don't you give us an update on where we are on that?
Sure. So where we are right now is, we are very lean, and we will continue to be for the foreseeable future. But there was some concern over the summer that the level of cuts that the OJD was potentially expecting that would have been then passed down to us would have put us at a level where we couldn't even afford to operate. I worked with the financial folks at UO. We have a new person who's handling all of our administrative matters in law school, and we kind of worked out a budget. And for a while, we were pretty concerned. We did get in the OJD request that eventually did go through. They basically kept us even for a 2-year request. The yearly, it works out that in the past, what we were given for FY 20 and 21 was $160,221 a year. The way the budget request has been submitted from OJD for FY 22 and FY 23 was $167,110. So it's a very small bump, but it is not a decrease, and that is remarkable from the conversation we were having earlier with OJD. Now, as you all know, have been through the budgeting process. That is certainly not a final decision. We've been cut the last 2 cycles once the final budget has gone through, once the OJD budget's been reviewed by the various committees in the House and the Senate. But it looks like the numbers we put together, we at least are going to be able to operate at the capacity we've been doing since the commission has moved to UO. I cannot speak. And I don't see a path right now without any significant raise in funding for us to get to the level that for some time it was operating with at Willamette. Going back into, Elaine, you would know this better than me. I was not involved, but there was periods of time where the commission had at least 3 or 4 full-time employees and was operating at many more projects a year. I think where we are currently with that budget, where we basically pay for the director's salary, some level of admin, some student support, and then just basic phones and office supplies and things like that, with really no money to spare. Part of the reason we've been able to operate in the last few years is that when it transitioned from Willamette, there was actually for all intents and purposes, the commission didn't operate for about a year in terms of having a director. And so that money was saved, and that money has been used to fill in holes in the budget up until this current fiscal year, where that money is not run out, but it's not at a point that's going to be sustainable moving forward. Where we are, we thought we were going to have to completely cut and actually Debbie, who's helping us, was actually prepared to actually cut the 0.5 admin position down to a 0.2 in January. That actually got changed because of a couple things. One, we were expecting a 10% immediate budget cut potentially from over the summer. That did not happen. We planned for it, we budgeted for it, but luckily that didn't happen. And the second thing was I had mentioned that I'm doing additional responsibilities for UO Law School right now. So part of my salary is now being paid for by the law school, which then saves that requisition money for the time being. But that's not going to be a permanent change as well. So that's kind of where we are. We are at a point that as long as the OJD's numbers that they've submitted are not cut drastically, and we've budgeted even for a 5 or 10% cut, we actually think we can handle that for the next biennium without a change in our service level. But it keeps us very lean. We definitely don't have, we did not submit, the 2 sessions prior to this, we submitted policy option packages to be considered for a staff attorney, which is a position that the Law Commission had in the past and was crucial. It was rejected both times, and because of the state of the budget during this session, we chose not to. And I consulted with the folks at OJD and with PK, and that was not something we chose to do. I think it would have been a bad decision. But until we would have additional staffing, I think that where we currently are, roughly 4 to 5 active projects at a time, I think is the capacity that my position can work with. And that's with the travel that I was doing back in 2019 from Eugene up to Salem and Portland. That's again a huge change from when it was at Willamette as well, is because we're now based in Eugene. So that's kind of a bigger picture of where we are. I feel okay. I think we can continue our operation. We continue to do good work, but we're not in a position of growth.
I think it's good to continue thinking about what projects we take, so as to continue to demonstrate our value to the legislature, to continue to think about alternative sources of funding. Like, for example, when we did the harassment project, that was important enough to the legislature that they gave us additional FTE. So there are ways to do that. Sandy, I know you've been very successful in continuing to work with fellows. And we've also discussed the possibility of, in the future, maybe in less strange times, looking at ways to get grants and things like that. We do have the ability to bring in funding from elsewhere to the extent that those things are important. And while we don't want to compromise the objectivity of the commission, so we need to be very careful in where we take funds from. We may be able to get funds from places who are interested in exploring particular areas, so long as that doesn't appear to prejudge any kind of outcome. That's probably the most important thing to me. So that's where we are. I think it's good that we're not imperiled as we thought we may have been before. But I think I think that we're still operating at less than the capacity that we would really like to, both on a staff level and I think on a membership level. So should we talk about new members then?
The last thing, PK,
Yeah,
the last
please.
thing I wanted to mention is I saw that Dexter had joined from Legislative Council, and also Lorianne was here earlier. The one thing that is a remarkable piece and the work that's put in is just, when we relate to our budget, we get an incredible amount of work, which is done by our partners from Legislative Council's office. And that is part of the reason why we can afford to operate the way we are, because they are doing the heavy lifting of being at the meetings and actually writing the bills and making sure we're being compliant with language. So I just really do want to, when it's compared to our budget and our ability to actually operate, I really, really do want to thank Legislative Council, because they're a crucial partner there.
That's a great point. Thank you, Dexter, and thank you for all your group's hard work. Does anyone have questions about the budget? Okay, hearing none, then we'll work to our last topic, which is new members.
So PK, I don't know if you want me to introduce, I can tell you where we are, which is that we're currently down 2 members, and they are both from the same category. And that's been a challenge. We are missing our 2 members who are from the Oregon House of Representatives. We have One has been vacant since Lane decided to leave the commission. The other is vacant since Jennifer Williamson resigned from the legislature. So I have tried to get in touch with the Speaker's office on several occasions, and I just haven't had a lot of luck. The one thing it is constraining about these two particular positions is they are dedicated to a current or former member of the Oregon House of Representatives. Those are the only people who can have these roles. They can be current or former members from any period of time, but that's what we're missing. Our other roles are currently filled. I was looking through terms today. The ones that I wanted to check in with is actually the Bar Association, and I'll contact Susan Gravy offline on those. The other positions look like we're within term, from my understanding. And then many of the positions on the Law Commission are actually not termed out. The judicial positions and the law school appointed positions don't have a specific term related to them. But we are missing our folks in the House, and I think it's worth a discussion on recruiting those two members.
And I intend to send a letter to Speaker Kotek soon about that, asking her to prioritize appointments, because I believe she's the one who needs to make those appointments. Isn't that right, Sandy?
Yes.
Yeah. So we can make suggestions to her, of course, about folks who we think might be useful. But in the meantime, if anyone has thoughts, please do let us know. In addition, I think I may have a conversation with you at some point, Susan. As the bar considers, who to appoint to the commission, it's been my goal to diversify the commission in our perspective and in our practice groups and in our regions. But I think it's important that we bring in voices that don't come from the dominant racial and socioeconomic groups as much as possible. And I'd like to urge the bar to think about that as it's making appointments going forward.
Thank you, PK. And that is part of the bar's mission as well, to focus on that more. So we will take your comments to heart, and just know that that's a part of the bar's mission at this point as well.
Thank you. Thank you. That would be very helpful. Of course, I don't want to lose the wisdom that we have on this group, and it's not my intent to push anyone out, but I think as that natural turnover happens, we should be considering that. This would also be a time at some point, I'm not going to put anyone on the spot, but if anybody is considering, whether they might want to step away from the commission at some point, it would be helpful for us to know for planning purposes. We're so glad to have all of you and all of your wisdom and experience, and we don't want anyone to leave. But if you do, please let us know so that we can be looking for the right replacement at the right time. Any more thoughts about membership or discussion of members? Okay. Well, hearing none, anything else we should discuss for the good of the order?
Just looking at PK, I was going to talk about just future scheduling. It's a different experience. The online meetings work quite well, but it is a different experience from us all getting together. I think we try to meet quarterly. We didn't quite hit that this year, but we did have 3 meetings, and I think that and we were able to get our work done. So I think that where we are now in January, I really want to see where the session goes. I think that a lot of folks who are involved with legislation are going to be interested to see the timing and when everything takes place. But looking forward in my mind to another meeting sometime in late spring, early summer is kind of where I am right now.
Great. And at this point, I think we should be thinking about that as a remote meeting. Depending on how things go, I am cautiously, well, not optimistic, but I'm hopeful that we might be able to all be together again sometime in the fall or winter. And I'd love to have another meeting down with our hosts at the University of Oregon at some point, when and if that becomes possible.
And we also want to take up Judge Bouchong on whenever we're able to take up on his offer to have a meeting in the new courthouse in Portland, whenever that's possible.
That's right. I saw a friend of mine who was recently sworn in to your ranks, Judge Bouchong, standing in the beautiful courthouse, and I would love to see that myself.
I come here every day, and it's a wonderful facility, and we look forward to the opportunity to hosting events and having more in-court proceedings as soon as we can. Right now, we're extremely limited under the Chief Justice order on the things that we can do in the courthouse. But yes, we got lots of room and happy to host.
Wonderful. We all look forward to that day. Well, hearing no other topics then, I suppose we should adjourn. Does that sound good? Okay. Hearing no objection, we're adjourned. Thank you so much. We'll be in touch.
Thank you, everyone. Happy New Year.